It is my pleasure and an honor to introduce the panelist and moderator of our second panel, Energy, Infrastructure, and Culture. Our panel will begin with weaving breaches from grass, finding native and Western legal and cultural perspectives to resolve conflicts by Greg Smith, partner at Hobbs, Strauss, Dean & Walker. We will then hear from Larry Roberts, counsel at Kilpatrick Townsend, former Acting Assistant Secretary of Interior on Federal Consultation and Collaboration as Bridge Building. Our panel will conclude with tribal perspectives on the Dakota Access Pipeline by Nikki Ducheneau, partner at Fredericks, Peoples, and Morgan LLP. Of course, we could not host this panel without assistance from the wonderful mock team-mails, Assistant Professor and Co-Director of the Marjorie Hunter Brown Indian Law Clinic here at the Law School who will moderate. Please join me in welcoming our second panel.
Thank you, Lillian, and welcome everyone. I hope that those of you in the back can hear me. I'm not going to try and use a mic. I appreciate your patience with some of our technical difficulties. I think we got those worked out, but it wouldn't be a good conference if at least we didn't have a few technical challenges, right? I just want to take a few minutes to set the stage for what will be an excellent panel. As the panel's already pointed out, these are practitioners, people practicing the law a little bit differently from the academics in the last panel. And I'd encourage you to recognize the different perspective that they might bring. You've heard a lot about the new era. It is indeed part of our theme, Bridging Divides in a New Era. And that certainly the technologies that you've heard already about are new and exciting, whether they be fish balls or regulatory reform perhaps, or even choices about values that maybe weren't around long, long ago. Questions about renewable energy or solar technology. But when it comes to tribal consultation and the relationship between the federal government and federally recognized Indian tribes, what we're talking about is the oldest practice in the country. It was, of course, at one time, all Indian country. And tribal consultation really began when non-Indians arrived. And so the purpose of this panel is to remind us that those ongoing relationships between tribes and the between federally recognized tribes and the federal government are ongoing. And maybe the new era simply presents new challenges. Cultural divides, interest divides, questions about authority, potentially questions about the effect of regulatory reform on the federal government's trust relationship. We need only look back a year ago to the plains of Cannonball Mesa, North Dakota, to recognize how these divides may create challenges, may inspire protest, and may ultimately be answered with positive solutions. Just a couple of framework, baseline concepts to keep in mind. There are statutory bases and legal requirements for tribal consultation, perhaps the most prominent being that of the National Historic Preservation Act, Section 106 process for requiring consultation with Indian tribes about federal undertakings that may damage or otherwise interfere with tribal cultural property. But we're also primarily focused with regard to the interaction between executive agencies and federal Indian tribes, largely set out in an executive order from President Clinton in 2000, Executive Order 13175. And it might be helpful to keep in mind the fundamental principles set out in that executive order with regard to tribal consultation. The United States has a unique legal relationship with Indian tribal governments as set forth in the Constitution of the United States, treaties, statutes, executive orders, and court decisions. Since the formation of the Union, and I would note, even before the formation of the Union, the United States has recognized Indian tribes as domestic dependent nations under its protection. The federal government has enacted numerous statutes and promulgated numerous regulations that establish and define a trust relationship with Indian tribes. Our nation, under the law of the United States, in accordance with treaties, statutes, executive orders, and judicial decisions, has recognized the right of Indian tribes to self-government as domestic dependent nations. Indian tribes exercise inherent sovereign powers over their members and territory. The United States continues to work with Indian tribes on a government-to-government basis to address issues concerning Indian tribal self-government, tribal trust resources, and Indian tribal treaty and other rights. The United States recognizes the right of Indian tribes to self-government, and supports tribal sovereignty and self-determination. How do those fundamental principles play out? We're going to hear from our panelists about ways in which the federal government consults, ways in which tribes engage in that relationship, and we're going to begin with, perhaps, a proposal to reform that relationship.
Thank you, Monty. Greetings, everybody. It's a thrill to be out here. This is really only the third time I've been to Montana. Each time I say, I've got to move out here. Rockville, Maryland, the view out my window in Rockville, Maryland is not as nice as this view. Let me say I'm very impressed by the conference. The students did a phenomenal job of reaching out and communicating. Lillian, Emily, Jonah, and I'm sure the others. And first panel blew me away. Everything they said was of great interest to me, because I'm a very strong believer in integrating other concepts into the law, moving away from a legalistic way of solving problems to one that integrates a number of different perspectives. And in fact, that's basically the theme of my presentation. I took very seriously the title of the conference, Bridging Divides. And you'll see my subtitle of my presentation, Weaving Bridges from Grass, and it will be evident in a moment why I chose that image. But bridging divides is a huge problem in Indian law. Much of Indian law is actually based on the existence of a Great Divide. And that became extremely evident in the Dakota Access Pipeline conflict. Nikki will be discussing that in detail. But I just wanted to put up here some of the language that was being used in that conflict, because I think it's relevant to this discussion. It's very severe language. So, the DAPO security forces referred to the water right protectors as terrorists, and their activities as attacks, and their camps as a battlefield. Well, when you start invoking the language of terrorism, you're plugging into the greatest global conflict of our age today. And in response, the tribal leader said, if anybody's a terrorist, it's them. But once the rhetoric gets to this level, is it possible to move forward? At this point, neither side is seeing the humanity of the other side. Now, I've represented a particular side in this. My firm represented the Oglala Sioux tribe in its work on the Dakota Access Pipeline. But in that effort, you're trying to win. But more broadly, how are you trying to win in the long run? How do you construct a system that actually gets to results that both sides can live with? I have a quote here from the Chief Justice of the Navajo Nation: where the legal system ignores the emotions of the parties, there can be no restoration of relationships. And I think you can replace the word emotions with cultural perspective. Where the legal system ignores the cultural perspectives of the parties, there can be no restoration of relationships. So here's our situation, just looking at the Dakota Access Pipeline conflict. With near zero respect between the two sides, how do you resolve that conflict? How do you prevent future conflicts of that magnitude? So I started thinking about bridging divide, bridging. And what came to mind eventually were the Inca rope bridges. And I don't know if you're familiar with them, but there's actually one in Washington, D.C. There's an exhibit on the Inca Road at the National Museum of the American Indian, and they have a little small Inca rope bridge there. That's one of only two in the world. But what struck me about Inca rope bridges is, first of all, they were the first suspension bridges in the world. When the European colonists arrived, there were no suspension bridges in Europe. The Inca Empire had hundreds of them. This is how they linked their mountainous empire and maintained control over a very large region of South America. But they're made of grass and vegetation, and you could shred the grass in your hands. But woven together properly and maintained properly, they could carry, horses could go across, and all kinds of loads could move around the trade and commerce of an entire empire. In fact, in a significant way, the rope bridges facilitated the Spanish conquest of South America. So I'm thinking, okay, rope bridges is a great concept. We got a lot of grass here, it doesn't seem very strong, there doesn't seem to be much of a basis for building a system that will work better than what we saw on Dakota Access Pipeline. And so I thought, what would work? What could be woven together? And as I went along, lo and behold, I discovered that the Pulitzer Prize in 1928 was given to Thornton Wilder for a book based on the Inca rope bridge, The Bridge of San Luis Rey. So I actually have read that since in the last 3 weeks, just because it struck me. And in that case, that was an example of an Inca rope bridge that broke. It had not been properly maintained, and the consequences of that for the families involved and all that came from that. So the other Inca rope bridge that still exists in the world is this one. And you can see that it'd be pretty tough to walk or make your way across that river without that rope bridge. And it continues to be maintained today as a tribute to the history of rope bridges, and the local villagers, as they were required in Inca times, are obligated to maintain the bridge, and every year it has to be maintained. So again, I have this concept of a rope bridge to somehow reach between energy companies and tribal interests, and I'm thinking, well, the only way people can resolve things is if they come to respect each other, and if their views, both views are implemented into the conflict resolution system. Now, this is kind of Law 101, but speaking very broadly, I know there are plenty of exceptions, but the Western perspective, and by that I mean a Euro-Western, not a out-West perspective, Western law is set up around an adversarial system. There are exceptions, mediation, alternative dispute resolution, but when there's a conflict, we head to court. It's a very legalistic approach. There are values. Those values are embodied in the laws. And you try to implement the values that are embodied in the laws. But the native approach, and I'm not the world's leading expert, but a lot of research and a lot of talk about this, is a relationship-based approach. And the most famous example are the peacemaker courts. And there you build your resolution around relationship between and among the parties. And I'm not, in this case, talking about the government-to-government relationship that tribes have, but really a human-to-human relationship on the grounds. So the question that then rose in my mind was, does it make sense to adopt a system that twines these two perspectives together? Is that even possible? Can we bridge the divide if both systems get full play and full respect? Well, I thought I should talk a little bit about each system. So in the DAPL case and in many other conflicts, the Western system has a huge body of law that addresses these issues. And you can see the National Environmental Policy Act, the National Historic Preservation Act, Section 106 was mentioned earlier, a variety of executive orders. There's a huge body of law representing the Western approach to solving exactly the kind of conflict we saw in the Dakota Access Pipeline situation. And it didn't work very well in the end. So he said, well, is there a better way? It made me think deeper about the nature of Western law, and I wanted to show this image. This is the world's largest equestrian bronze statue. And it is outside of the El Paso airport, where it is guarded day and night because of the nature of the figure that it glorifies, Juan de Oñate. He's known as the last conquistador. He led Spanish colonists into the southwestern region of the United States today. There he's depicted on his horse rearing in glory and power. But what struck me, and the reason it has to, well, I'll tell you why it has to be guarded, but what struck me was he's not waving his sword in triumph, he's holding something in his right hand. That something is called La Toma, the taking. It is the legal document that gave him the authority to seize the Southwest. In other words, law was being used against the interests of Indian tribes and Indian peoples. And he famously wiped out 3 whole pueblos, and when he came into conflict with Pueblo of Acoma, cut off the right foot of every Acoma male. And they put a statue up to him, a statue of him in Santa Fe on the 500th anniversary of his arrival in the Southwest, and somebody in the middle of the night cut the right foot off. They blamed Acoma. I represent Acoma. There's no security beat there. I have no idea who has that right foot. But they welded on a new one, and they moved that statue in front of the police station. And this much larger glorification for Juan de Oñate is at the El Paso airport, where it's safe from an updated statement on the meaning of history. So, the law has been used as a weapon against tribes. So why would tribes be naturally comfortable with the law? Even though every day in Washington, people like Larry and others are fighting a way to affect the laws in order to advance tribal interests. Well, they have a lot of reasons to distrust the law. But if you look at the federal system of law, it provides, and this is very broad, I'm being very broad here, this is broad brush, but you resolve conflicts under the federal legal system either through a lawsuit principally, or there's this mechanism called consultation, sort of intended to anticipate problems and minimize lawsuits and resolve disputes. And unfortunately, it's my belief that consultation as defined under the federal system works very poorly due to some fundamental structural problems. So, consultation, and you can mostly think of Section 106 consultation, but there are a variety of other consultation requirements. Consultation assumes that the parties are seeking in good faith and believe that the other party is seeking in good faith the best win-win outcome they can achieve, and actually have some level of understanding of each other. A consultation isn't going to work if one of the parties is not operating in good faith. And there's a quote actually from the Bridge of San Luis Rey. Brother Juniper is writing about those who died when the bridge failed, and people are telling him about their lives and stuff in the book. Thornton Wilder writes, everyone knew that he was working on some sort of memorial, and everyone was very helpful and misleading. And I think about that in terms of all the work on Dakota Access Pipeline and how we felt about the representations of the company, what the company was saying about the representations of the tribe. And once the system collapses into that, there's very little chance of working out a win-win solution. So even just the belief that the other side is not acting in good faith destroys the process. The only way you can overcome that distrust, a distrust born on years of law being used as a weapon against tribes, is actually through relationship. So, what are, I think, the fundamental flaws in the consultation process? Well, what if the consultation process reflects a bias in favor of one side? And let me give you an example. My wife and I occasionally go to the beach with our kids near Washington, D.C., and if we're down there and we don't have much money on us, she's got a few bucks, we're hungry, and she says, look, I'm going to go up and get a small pizza. And I go, great. And she says, well, what do you want on it? And I go, I want the meat lover's special. And she goes, she wants the vegan special. So I think, oh, well, my wife loves meat, we'll compromise. And I said, oh, okay, maybe it can be kind of half and half. And that's when she says to me, Greg, you need to start making better choices. Hear that sentence? And up she goes, and what comes back down is the vegan special. Well, in consultation, the federal government consults, or the industry in some fashion, but really the federal government consults. But between the two parties, only one of the consulting parties actually gets to make the decision. So that is a structural bias in a consultation built heavily in favor of the federal government and excuse everything that could happen. And you always hear tribes talking about, we want meaningful consultation and so forth. I know a number of tribes who are coming forward now saying, we don't want meaningful consultation. We want, if there's a substantial impact on a tribal interest, you must get tribal consent. And without that, the process is just so strongly skewed towards the federal government that it's going to be pretty hard to build trust and build a relationship of trust. So that's one problem. Also, the consultation process may reflect the bias of one side. So not just towards one side, the federal government, but the bias of one side. And some of you have seen me present on elements of this before. But if you go to the U.S. Capitol and you visit the Capitol Dome, how many people have been to the Capitol Dome? Okay, wow, it's a room full of lawyers for sure. Okay. So it's a great glorification of the American democracy. And there are enormous paintings on the walls, and many of them have many very interesting messages, which I do not have time to go through. But here's the one depicting Christopher Columbus setting foot in the New World. And notably, he's planting a flag. We know that's a statement of sovereignty, right? The national narrative is European sovereignty over the New World. There's the flag. And behind him are his men. In the lower right, in the trees, it may be a little hard to see, are the natives who are hiding in the woods, watching this sort of grand procession arrive on their lands. Artists, being subversive, have put in the lower left some of Columbus's men down in the sand. What are they doing? They're digging for gold. Ultimately, Columbus's expedition was based on economic values. I was very struck by the commissioner's earlier comments about an economic analysis. And Columbus's expedition, in many ways, was about an economic analysis undertaken by the Spanish Empire. So that's the national narrative. We're all very familiar with it. Just to swing over to a few other examples of that national narrative, this is the Senate wing of the U.S. Capitol. So if you were there, you probably walked right by this. I know people who worked on the Hill for 10 years and walked by the Senate wing. These statues are huge, but they're really up high and they don't know what they depict. They actually depict a story. It has a theme. The theme is the progress of civilization. And it begins the progress on the right side. That structure is actually called a tympanum. I had to look that up. But if you go to the right side, the first statue, the first structure, first sculpture really, is that low mound. You can look it up. It's an Indian burial mound. That's the start of the progress of civilization. The second one is a native woman comforting her crying child. As the triangle gets bigger, the third one is a dying Indian chief. These are the official names of these statues. The fourth one is a native youth watching a pioneer cut down a tree. Natural resources development. And then the fifth, not depicted, is a Statue of Liberty figure, and then a George Washington figure, and so forth. That is the progress of civilization in the national narrative. Having gotten the 5-minute warning, I'm going to skip some other very interesting slides about the ironies of this national narrative. You go to modern times, because you can say, well, the U.S. Capitol was built in the 1850s, and I'm glad there were some subversive artists then, but things are improving in a variety of ways. Well, I'm going to give you 2 personal stories. A few years ago, I was working closely with the former general counsel for the U.S. Department of Agriculture. So he had been a big-time player in a very important agency, department. And we were working on a native matter. And one day he said to me, and he was not an Indian law specialist, this was the only native matter he'd ever worked on. One day he opened his heart to me in some fashion. He goes, you know, Greg, Indian peoples, they build a fire, then they dance around it and declare the land sacred. And I was like, oh my gosh, this is so wrong on so many levels. Where do I even begin? And, but the attitude was one of skepticism about the veracity of what Native people are saying about this is spiritually important to us. And if you think about Christianity, and I'm a devoted Christian actually, but Christianity believes it's universally true. So as a theological concept, even if individual Christians have differing beliefs, Christianity isn't going to be very respectful of other systems of belief. And this gentleman was very dismissive of the legitimacy of tribal claims that land was sacred or anything associated with that. Second story, I was in a meeting with the director of the Bureau of Land Management with a couple other tribal leaders, and the BLM director, I made a point about the trust responsibility. I was trying to keep that in the fore. And she snaps back at me and says, the trust responsibility is a factor, just one of several factors. Well, once the trust responsibility, which is a legal obligation, becomes only a factor, it will be overwhelmed by all the other factors. And you have now diminished it to the point where it's not significant. So listening to these 2 officials, one former and one active, diminish the significance of the tribal perspective, whether spiritual or legal, was really troubling. And that's bias is built into the consultation system. Now, one quick thing, you're a group of lawyers, you all know what a writ of mandamus is. There's another writ that was similar to the writ of mandamus, but isn't used anymore, and it's actually the writ of consultation. And you can go look this up. The reason it's not used anymore is because it is an order by a court to return a matter that is in the secular courts to the ecclesiastical courts. And I was struck by this because what does consultation mean? In historic times in the British system, consultation was associated with matters that are spiritual in character and need to be in the church court system, the ecclesiastical court system. So in its origin, it has that component. So I have to celebrate. Okay, I'm going to grab a little bonus time. Only 200 slides left. And, all right, so is there a different perspective that's possible? This is that same rope bridge. By coincidence, I was in New York City last week at the Whitney Museum, and there was a painting of another suspension bridge, which is the Brooklyn Bridge, right? That technology has now been adopted in the Americas, but it was pioneered by the Incas. So the concept I wanted to talk about is peacemaking. And we think of the peacemaking courts as focused on dispute resolution, and they are. But at their core is sitting down and talking about the relationships within the community and reaching an answer, often put down in writing, so something that would be of comfort to businesses, that is based on the value of the relationships in the affected community. And I'm thinking, all right, can we twine that concept together with the more litigative approach of the Western system? And just a few more things. Peacemaking often has a spiritual dimension, which is very important to tribes in a lot of these discussions. Often it's actually the driver. It can lead, though, to a stronger business relationship at the other end, as I will show in a few examples that I will give. Western law does have analogs, alternative dispute resolution, mediation, and so forth, but they tend to come after a dispute has begun. And I'm talking about taking these native values of relationship and putting them at the front end before a dispute has occurred. And there are some examples that have been adopted by industry. So, for example, in Burundi, a company went in to do a major development, but before they started, they knew they were going to face some serious opposition. They secured a nonprofit organization to organize a 5-day retreat. And the company officials and the tribal villagers and tribal leaders retreated for 5 days, just to get to know each other, just to talk about how this might go, just to share their values. And it began to bridge the divide. Similarly, and I have to tip my hat to Troy Ide, as I drew this from his writings, but the El Paso Ruby pipeline was able to move forward because before construction began, the company sat down with tribes along the route and reached written agreements that included funding. Tribes don't have the resources to do the historic preservation work for the companies, but they have knowledge that the companies cannot access, that they shouldn't have to provide for free. Second, those same agreements dealt with tribal monitoring of the project. That gives tribes confidence. They're there watching, eyes on, and make sure there's no surprise deviation. The company offered tribal employment. The country did a lot of what are called micro reroutes in response to tribal concerns. And the company later said it probably saved hundreds of millions of dollars because it didn't have to fight tooth and nail, because it reached these agreements before rather than during or after. Similarly, the Pueblo of Acoma had to deal with uranium mine development and pipeline development, and they too have gone to the companies in those cases and reached written agreements in advance that address cost issues, confidentiality and timelines and so forth. So in those situations, you have the companies being told or coming to understand that they better deal with the relationships in Indian country first before they start invoking the law and whether they checked off the correct series of boxes such that they're going to win in court at the end of the process. So in my concept, consultation would be expanded into a consent requirement for tribes, which will be fought, but also something that is achievable and industry has achieved to its own benefit, a relationship building stage at the beginning. So it's like one anchor on our rope bridge, and on the other end of the anchor is eventual recourse if matters cannot be resolved to the Western legal system, because we're not going to get away from that. What happens if we don't achieve this? Well, back up. Can you back me up one? Somehow got ahead of myself. One more. Right there. This is the Dakota Access, this is the Native March on Washington and the White House in objection to the Dakota Access Pipeline. You can't see them very well, but they're stretched around on that white building on the left. Ironically, that is the Government Accountability Office, trying to hold the government accountable. To the left is a former military building, and you can see a kind of tan line that goes around that building. If you go right up and look at that, it's little friezes of soldiers marching. Literally thousands and thousands and thousands of soldiers marching around that building. You've got 2 marches going on, 2 armies in the field. And this is a bad outcome and will lead to bad conflict, as we saw on the Dakota Access Pipeline. So that's what happens when the bridge isn't in place to span the divide. One final slide, which is this picture. That is that same Senate wing with the tympanum behind, with its statues depicting the progress of civilization. But below it are a group of major tribal leaders who gathered in Washington as a tribal unity effort, and also to create a different narrative. Right? That narrative is wrong, and that narrative failed, even though it's built into the stone of our Capitol building. There's another narrative that needs to get equal and full respect. And so, in closing, this bridge has to be built, I say, first on relationships. Second, the bridge has to be maintained. And one last quote from the bridge of San Luis Rey in the novel at the end. Thornton Wider writes that the collapse of the bridge led to a proverb. And the proverb told among the people of that region was, "My cousin lives by the bridge of San Luis Rey." And he goes on to say, and a smile goes around the country, around the company, whoever's sitting there when that's said. For that also means under the sword of Damocles. And the Dakota Access Pipeline was an example of the sword of Damocles falling, thin thread being severed. So my point as a lawyer is really nothing legal. It's all relational. I believe that law and these problems are largely solved by psychological approach, frankly. So I hope that's helpful. That's a practitioner's perspective. For those of us who fight for Indian country, we'll fight just as hard as possible in the Western legal system. But if we're taking a bigger view about what might be better and what might protect Native interests in the long run, the Indian country has the wisdom to give to the business side, which is this must be a relation and not a lawsuit. Thank you.
Greg, Larry?
So can folks hear me in the back? I don't think that this microphone is great. So I just want to start off by saying thank you to the law school. Thank you to the law students that have put on this fantastic program. I am Oneida. I'm from Wisconsin. I went to the University of Wisconsin Law School, and our Indigenous Law Students Association puts on a conference every year. And so I know as a former student how much work goes into this, how much time it takes, how much the preparation and planning, and today you're missing classes and tests and things to put on this fabulous conference that not only benefits the law school, but benefits the surrounding community at large. I want to just spend a moment to say that I had the opportunity to serve at the Department of Interior during the last administration. It was the honor of a lifetime to work with tribal leaders across Indian country to move things forward. And for you law students out there that are thinking about your next endeavor, your next job, I would encourage you at some point in your careers to think about federal service, because the opportunities that you have working within the federal government are going to help you better serve Indian country if that's what you want to do in the future. Because maybe things will change, maybe we'll go to a paradigm of, instead of consultation, consent at some point in the future. But if we don't, you better serve your clients by knowing how the federal government operates and works in Indian country. So, clicker. Okay, so I want to talk about a few things before I get into some examples, but I want to first talk about, what's the origin of tribal consultation? Where does it come from? And as Monty mentioned, well, it's really embedded in the Constitution itself with the treaty clause. It's really embedded with the earliest treaties that the United States had with tribes. And it's also embedded in the case law. And so some of the cases are from the Justice Marshall, the earliest times in the Supreme Court's jurisprudence. So you have Cherokee Nation versus Georgia. And why is that case important? That case was decided in 1831. It was concerned, the Cherokee Nation brought an original suit, tried to bring an original action before the Supreme Court against the state of Georgia, trying to stop Georgia from applying its laws, taking Cherokee lands. And Justice Marshall looked at that case, and in his opinion, he defined tribes. He said, no, we don't really have original jurisdiction over this lawsuit. Tribes are not foreign nations, but tribes are domestic dependent nations, right? So Justice Marshall is recognizing that political relationship with tribes and recognizing the authority of tribes, but also recognizing this guardian-ward relationship in that decision. So a year later, Justice Marshall, Worcester versus Georgia comes up before the Supreme Court. And in that case, it concerned whether missionaries who had not obtained a license from Georgia, whether they could be prosecuted for going into Cherokee Nation lands. And in that case, the court said that, look, tribes have always been considered distinct, independent political entities, Treaties acknowledge their protection of the United States, by the United States, but just because tribes take protection from the United States doesn't diminish their sovereignty over their lands. And concluded that as a distinct community, that the laws of Georgia would not apply within the Cherokee Nation, within those Cherokee Nation lands. And so those really set up the basis, in at least the common law, for consultation and the federal government's role in consultation, I would argue. The federal government's role in consultation is between tribes and the federal government, and making sure that tribal sovereignty and tribal rights are respected in that, vis-a-vis the incursion of states, local governments, other entities. And so that's the federal government's responsibility. Consultation flows from these areas. So after these decisions were issued in the early 1830s, the federal government pursued a different policy in the 1870s, 1880s, 1890s. The federal government pursued a policy of allotment and assimilation. And I would argue most of the things that we're grappling with in Indian country today are trying to undo the harms of that policy, of that federal policy of allotment and assimilation. So if you look across Indian country, if you look across the challenges in law enforcement, you look at the challenges of jurisdiction, it all flows from those. Something, it's like something popped up on the computer there. It's not a big screen. Okay, great. So fast forward to 1934. In 1934, the Congress says allotment and assimilation, that hasn't worked. It's been a disaster. Tribes have lost tens of millions of acres of land. And Congress enacts the Indian Reorganization Act. One, to better support the restoration of tribal homelands, but two, to provide tools to tribes to assert self-determination. And so one of the sponsors, Senator Wheeler of the IRA, said a purpose of the IRA is to get away from the bureaucratic control of the Indian Department by giving Indians control over their own affairs. So again, recognizing that tribes, through a consultation process or through the law, tribes should be basically able to assert self-determination and self-governance. So that has been the policy over time. Fast forward to the relatively recent future of the 1970s, and you have Nixon's address, right? You have Nixon's special message to Congress. And he basically says, look, after the IRA, after this, the federal government took a policy of supporting tribal self-determination and restoring tribal homelands. Congress took another left turn in the 1960s and pursued, 50s and 60s, and pursued a policy of termination, of terminating that federal relationship between tribes and the United States. And Nixon in 1970 said, you know what, that was a disaster too. Termination was not only legally wrong, but it was also morally wrong. And he basically said, look, the federal government has pursued a policy of paternalism over time as well. That has been a complete failure. And so he says in his statement, both as a matter of justice and as a matter of enlightened social policy, we have to begin to act on the basis of what the Indians themselves have long been telling us. The time has come to break decisively from the past and to create the conditions for a new era in which the Indian future is determined by Indian acts and Indian decisions. So you have the President Nixon, embracing, again, not only tribal self-determination, but federal government needing to listen to tribes and needing to consult with tribes. You have President Reagan reaffirming that policy, the relationship of government-to-government relationship with tribes, and he pledged to pursue, again, a policy of self-governance for tribes, with tribes, and stated that by working with tribes to develop not only the statement and the policy, but he would also continue to work with tribes to implement the policy. So fast forward then, and I think Monty mentioned President Clinton issuing the executive order on tribal consultation, 1 through 175. For the first time, we have in an executive order definitions in terms of policies that impact tribes, when the federal government has a specific responsibility to consult, and how that consultation should move forward. And requires agencies to establish accountable processes for consultation. So that's in place. President Obama comes into office, and one of the first things that he instructs his agencies is he said, look, we have an executive order on consultation, but how is it working? Where are we falling short? Where do we need to improve? And how are agencies implementing this? And so from the very first years in the Obama administration, agencies across the executive branch went out and consulted with Indian country on consultation. So consultations on how to conduct consultation. And as part of those, each federal agency is now required to annually report on the results of consultation and where they're taking steps to improve consultation. Finally, I just want to touch upon federal statutes that Monty mentioned in terms of actually where Congress has actually required consultation, both in the Archaeological Resources Protection Act, the Native American Graves Protection and Repatriation Act, and then amendments to the National Historic Preservation Act. So we've got technical difficulties here. We're restarting, it looks like. But I want to talk about, and I know this will come up shortly here, I want to talk about, the second slide here is a picture of the day that the Army Corps of Engineers decided to deny the permit to the Dakota Access Pipeline. And obviously during the last year of the administration, Standing Rock was happening. Army Corps, Department of Interior, Department of Justice were all engaged on Standing Rock, but we also, the administration realized that Standing Rock was, it obviously made a calling that infrastructure generally, energy projects generally across Indian country, there needs to be a broader dialogue of how does the federal government work better with tribes to avoid these situations? How can we improve consultation? And are there changes that Congress needs to make in the law to improve consultation? And so, out of that, the department engaged in a number of consultations across Indian country. And as one of the speakers said in the earlier panel, I guess we do like to think sometimes that, oh, we did something new, we did something innovative. This is the first time that this has ever happened. It probably hasn't been the first time it's happened, but during the administration at least, it was one of the few times where agencies across the federal government came together and engaged in consultation with tribes on infrastructure development. So you didn't have just the Department of Interior or BLM or Fish and Wildlife Service engaging with consultation. You had multi-agency consultations with tribes all in the same room, all at the same time. So you had the Department of Energy, you had Army Corps of Engineers, you had Department of Interior, DOJ, Department of Agriculture, EPA, the Department of Transportation, FAA, all coming together and engaging over a series of consultations with tribes about how to improve consultation on infrastructure development. And so what did we hear out of those consultations? Well, the good news is at the end of that process, we put out a report because we thought it would be important for future administrations and tribes to see not only what was said at those consultations, but what the federal government heard and what the recommendations were. And so one of the things that we heard, which wasn't a surprise to me, but it may be a surprise to industry or others, is that tribes do want infrastructure. They do want, obviously, better roads. They want broadband. They want transmission lines. They want access to these things. It's a key to economic development within Indian country. But tribes need to be included at the front end, at the very start, rather than partway through the conversation. It gets back to Greg's example of the pizza. You know, tribes want to be at the table ordering the pizza. They don't want to be negotiating about the slice of pizza that they get at the end of the day. We also heard that the scope is too narrow, right? The scope is too narrow on these infrastructure projects. That it needs to look not at just the federal action that's being approved, not just the crossing underneath the Missouri River across core land. The federal action needs to look at the whole pipeline, the whole infrastructure that's being put into place. You can't segment this approach by just looking at the narrow federal approval. You need to look at the broader approach, the broader impacts, and also the cumulative impacts and the history behind that. Why were tribes feeling this way about this particular crossing? Was it because the federal government and the Army Corps of Engineers had already flooded tens of thousands of acres of tribal land already and are now proposing to put a pipeline, half a mile upstream from their homelands? We also heard that avoidance and protection should be the ultimate goal, not mitigation. So not mitigation of impacts, but avoidance or protection against impacts. And obviously that the federal government can have the best written tribal consultation policies, but it really comes down to the training of those federal officials on the history and legal rights and legal status of tribes. And the training, if federal officials have that training up front, it's going to lead to better informed, not only decision making, but being able to understand the tribal input that they're receiving at the front end. And then finally, tribes need resources. They need the ability and resources to actually engage in this consultation. Consultations are extremely expensive for tribes. It's travel time. It's preparation time. It's wondering whether a particular tribe has access to GIS specialists, environmental specialists, and so we heard that obviously there needs to be opportunities for federal funding to actually support that engagement. And finally, we heard a number of different legislative suggestions, including a requirement for mandatory avoidance of impacts on tribal resources for every federal statute that relates to infrastructure planning. So another important aspect of that report, which is online, is we also highlighted successes, best practices of where consultations have actually helped and made a difference. And so I will highlight one example of that just for purposes of time, and that is the FCC has put together, and this falls in the category of information and resources for tribes to be able to engage in consultations. The FCC has put together a database where folks that want to construct towers can put in not only the location of that potential tower, but project details about each project. And tribes can access that information and hear about it. And it's not a replacement for consultation, but it provides information to tribes to decide whether there is an issue with this particular tower or not, and if so, how to engage with the FCC on that. So I want to touch also briefly on an example of consultation at a landscape level approach. And so this is the Desert Renewable Energy Conservation Plan. It's, while it's not perfect, a number of tribes indicated satisfaction with the process and with the results. It covers 22 million acres, and so for context, it's about a quarter of the state of Montana. It's not a 3-month effort, it's not a 6-month effort, it's a multi-year effort. And it engages not only all of the different agencies within the federal government, but also states, local governments, and stakeholders. And so multi-level consultations where not only were there broader events for tribes within the area, 44 tribes, but there were also individual consultations over time. Couple of important things, results out of this, and that is one, mapping was incredibly important in terms of explaining and figuring out where renewable energy projects could be sited that would be appropriate. That would be appropriate not only to promote energy development, but also protect cultural resources. Turns out, not all that surprisingly, the biologically sensitive areas overlapped, as they found out, with culturally sensitive areas. And so there was a natural a natural grouping with those. Also, what they did in this context, tribes obviously are very concerned with disclosing specific areas of cultural relevance. So what they did is they used a heat map approach. They used a heat map approach on the map to say, okay, this is better for development, this is cooler. This area over here is either biologically or culturally sensitive. Let's stay away from those areas. So, in the interest of time, I'm going to slide quickly to the path forward. And so, a couple of things. One is, I think the best consultations are not one and done. They're not 2 or 3 consultations. They're consultations over a series of time. So that takes planning at the front end. That takes conversations at the front end to make sure that that people are being heard, because there needs to be a level of trust in the room. The other thing that I would say is that in a different context, I had the opportunity to work on a case in the United States versus Michigan. And United States versus Michigan is a treaty fishing rights case where the tribes had in their back pocket, the United States had in their back pocket, a decision by the Sixth Circuit saying that the tribes retained a treaty right to fish. It was paramount. And what we were negotiating with the state of Michigan, if we could reach resolution, was how to allocate that fishery. And so, getting to Greg's point earlier about, is consultation overly one-sided? Does somebody have too much leverage? Well, I would argue that litigation can provide that leverage to balance the consultation. And so what happened is, I came into the case in the mid-90s. The allocation was about to expire. And the state of Michigan, the sports fishing groups, and the tribes were not speaking to each other. Hadn't been speaking to each other in years, because the level of animosity had grown and grown and grown over the years. The litigation case was still pending. The court was telling all the parties, you all need to work together. You do not want me to decide this issue. It seems pretty common sense, right? But you had an active court basically saying, parties work it out. I do not want to decide this issue. We consulted over a course of years to reach agreement, and we did reach agreement because people around the table had the opportunity to start building trust, to start exchanging information, to see and start talking with each other and see the common interests that all of the parties had. And as a result of that, which it took basically 3 years to accomplish, as a result of that, the federal government, we reached a settlement. The federal government went back to doing its thing. The tribes in the state continued to talk. The tribes in the state reached agreements on tax agreements because those relationships and this trust had been built over time. So the tribes reached agreements on not only tax, but they reached agreements on the tribes' inland rights and allocations for hunting and fishing on inland. So, I have a couple of points on there about litigation, about legislation. Litigation is obviously leverage to, if all else fails, there always is litigation, but litigation can play a role to reaching a positive outcome in consultation. I would just call out that HR 2689 is a bill that's been sponsored by Congressman Grijalva over the last couple of Congresses. That is legislation putting teeth into consultation and providing tribes a right of action in federal court if consultation is not conducted according to his legislation. And then finally, I would just say that, put on everyone's radar, the White House Council on Native American Affairs is a council that brings all of the federal agencies together, all of the cabinet heads. It's focused on how can the federal government better serve Indian country. So it's not focused necessarily on the consultation between the United States and X tribes on X subject, but it's getting cabinet secretaries in the room together to say, hey, I have a law enforcement issue, or we have an issue with energy sightings, and we have the Secretary of Agriculture, Justice, Interior, and others around the room to see how they're going to work together to better serve Indian country. So thank you. I see I'm out of time, and thank you for your attention today.
Good morning, everybody. I'm Nikki Ducheneau. I'm a partner at Frederick Stapleton Morgan. Morgan, which is an Indian law firm with offices all over the country, but I work out of their Omaha office. I'm an enrolled member of the Cheyenne River Sioux Tribe. I'm also a descendant, first-generation descendant of the Confederated Salish and Coopee tribes just over here north of Missoula. And I graduated from the University of Montana School of Law 10 years ago in 2007. And so I'm so happy to be back, and I'm so proud of what the Public Lands and Resources Law Review has put together for this conference. And I am so happy to see that there's Native people on your law review, and that you have very properly and appropriately considered Indian issues in this conference. So, I'm going to walk you through 4 areas today. So I was honored, I have my dream job right now. I'm a litigator and I represent tribes in various areas defending our treaty rights, tribal sovereign immunity, but I was very honored to work for my own tribe as lead litigation counsel for the Cheyenne River Sioux Tribe in the Dakota Access Pipeline litigation, which is ongoing. In fact, we got an unfavorable ruling on an issue that I'll talk about the day that I was traveling here to come to this conference. So I'm going to talk to you a little bit about the history and the context behind the Dakota Access Pipeline litigation. I will walk you then through the litigation itself, including some of the interesting factors in that case where the water protector movement influenced how our litigation was going, and our litigation influenced the water protector movement. And then I'll give you a little bit of an update about where we are today, because we're kind of out of the news, but we are still doing our thing in court. And then finally, I will get to some of the lessons that we've learned about litigation and where we're going forward from there. Okay, so just to begin, I want to give you a sense of what the Lakota people, who are the Indian tribes at Standing Rock and Cheyenne River, and Oglala, who are involved in the Dakota Access Pipeline litigation. This slide shows our 1851 treaty territory. And these were lands that we reserved to ourselves in a treaty duly negotiated with the federal government. Supreme law of the land, as we know under the Constitution, but it actually doesn't represent our full Aboriginal lands. Our Aboriginal lands, because we're a nomadic people, we're all over this country. My Lakota forebears used to fight with my Salish forebears against the Blackfeet, so it gives you a sense of how far we ranged around. Through a series of events that you guys may be familiar with from history, our lands were diminished over time. In what the U.S. Supreme Court called in 1980 some of the most ripe and rank dishonorable dealings in history, and illegal abrogations of our treaty. So we retain rights to those lands because that abrogation was illegal. But as you can see from that map, the eastern boundary of our treaty territory was the Missouri River. And this is a picture of the Missouri River as it is today. Professor Benson talked about some of the core projects, dams and such. And so this slide shows what looks like a lake. And in fact, it is a lake. In the 1950s, the Army Corps of Engineers put a dam on the Missouri and flooded those lands out. But our people relied on the Missouri River as what we called a lifeline, a bloodline. It was from time immemorial how we traveled up and down and saw our relatives and traded. The best land, among our best land, was down there in the bottomlands of the Missouri, timber and game and what have you. And so when we lost that from the Pick Sloan project, it was devastating. The place where my father and my grandparents were born was inundated. But today, for both Standing Rock and Cheyenne River, this is our sole source of clean drinking water. The groundwater is not suitable on our reservation, which is the size of the state of Connecticut, to drill wells and pump that water up for drinking water. We have another river, it's actually the Cheyenne River, that's the southern border of our reservation. It's absolutely contaminated with mine tailings from mines in the Black Hills and completely unsuitable, full of arsenic. So the Army Corps of Engineers has helped us build a water intake that is in the Missouri River. It pumps water to all of our people. And just to give you some context, back in 2005, there was a severe drought on our reservation, and that water intake was in danger of being compromised. The Army Corps of Engineers produced a document at that time that indicated how absolutely devastating that would be for us. We would have no water. We would have no water to drink, to water our stock. There would be no water for the hospitals to run dialysis machines. It would be a crisis of epic proportions, as the Army Corps of Engineers called it. So it gives you a sense of how important that water source is to us. If something happens to it, it's an existential threat to my people. And so this shows where our reservations are today in the treaty territory, and it should demonstrate where that crossing of the Dakota Access Pipeline is. And as Mr. Roberts said, it was half a mile above the Standing Rock Sioux Reservation. And some of you may have heard in the news that originally when Dakota Access was considering this pipeline, they were looking at an area that was 10 miles above the community of Bismarck, North Dakota. This is, of course, a non-Indian community. And they did some public meetings and they found out, surprise of surprises, that the good people of Bismarck, North Dakota were concerned that a spill would happen and compromise their water supply. So, of course, Dakota Access kindly moved that pipeline just about as close as you can get to the Standing Rock Sioux Reservation without actually being on it and on our treaty. So I'm sure many of you have heard about the concept of environmental justice, which is something that we have litigated in this case. This is a problem that's ongoing throughout Indian country. You have heard of other pipelines. The Line 3, which is up in Minnesota, at KXL, should have heard of. But I will give you these DAPL facts. So the DAPL is a 1,200-mile long pipeline that will move, and does today move, about 500 gallons of crude oil from the Bakken fields to Illinois. So there's no federal permitting required for siting the pipeline on private land. So Dakota Access, early on, before they made any overtures to the Corps, began making arrangements with private landowners. And in fact, before permissions were granted by the government, they had about 90 to 95% of that pipeline constructed. But there is a permit required under Section 408 of the Rivers and Harbors Act for occupation or alteration of a Corps project, which the Lake Oahe is a Corps project, and so permitting was required for that. And in addition, Dakota Access needed an easement under the Mineral Leasing Act to cross Corps land. And then there's also this nationwide 12 permit and conditions related there too for Corps crossings that are sort of random. So to give you a sense of how close it was, you can almost, in my little picture, you almost can't see the space between the pipeline and the reservation. And you can go ahead and compare with Keystone. It's almost like they're deliberately targeting us. It feels like, I know they're not, but you know, it's pretty stark. And so because those federal permits are required, there was an early administrative process. June 2014, Dakota Access notified the intent to drill under Lake Oahe. Dakota Access prepared a draft EA that the Corps ultimately adopted. December 2015, the Corps published and sought comment on Dakota Access draft EA. So we've talked about consultation. Tribal consultation is required statutorily by Section 106 of the National Historic Preservation Act as to historic properties that have religious and cultural significance to Indians. Tribal consultation is also required as to impacts to tribal treaty rights and trust resources for the Corps' regulations, as well as general principles of federal Indian law. And of course, we've talked about what it means to have meaningful consultation. We know that in these sort of processes, the public is entitled to attend public meetings and submit comments. So of course, tribal consultation must be something more than that. If we have a specific right to tribal consultation, it has to be more than picking up some materials and speaking on the public record at a public meeting or having a few phone calls with the Corps. So in this instance, consultation arguably occurred, but specifically on Section 108, DAPL archaeologists engaged in tribal consultation under the NHPA in a manner that the tribes felt was grossly deficient. They didn't get in contact with our tribal leaders. They were in contact only with our tribal historic preservation officers. They conducted big public meetings around Indian country and did not respond appropriately to our suggestions, to our concerns about sacred sites and sacred lands. And it was a fraught process, to say the least. And importantly, the Corps made no explicit or affirmative efforts to engage in tribal consultation as to treaty rights or trust resources, which is shocking in light of the fact that those treaty rights and those trust resources are promises that the United States government made to us. They are resources that they are bound to protect. And yet it was the position of the Corps that because it was not specifically required by statute, that they didn't have to make any affirmative efforts, and they didn't. And so in our late administrative process, Standing Rock and Cheyenne River brought all of our concerns to the attention to the Corps. Our concerns about spill risk, environmental justice, our concerns about the sacredness of the water, the uses that we have in our religious sacraments of that water. And we requested an EIS. And of course, they didn't do an EIS, they only did the EA. The Department of Interior, thanks to Mr. Roberts, submitted comments requesting an EIS, given the potential impact on trust resources, not just our religious and sacred sites. The EPA and the Advisory Council on Historic Preservation also weighed in. But, as we know, the Corps issued the final EA, which cursorily addressed impacts on water resources and environmental justice, only as to discharges as part of the construction process. They did not do an analysis as to the spill risk. And they concluded that given new mitigation measures and evaluation of DAPL's anticipated environmental, economic, cultural, social, and cumulative effects, the DAPL crossing would not significantly affect the quality of the human environment, and therefore no EIS was required. And so it was from that position that they granted the permit under the Rivers and Harbors Act, and we began litigation. And so that litigation started on July 27th, which was just a couple days after the Rivers and Harbors Act permit was granted. Standing Rock initially sued, Dakota Access successfully intervened as a defendant, and then my tribe successfully intervened as a plaintiff shortly thereafter. There was an initial preliminary injunction proceedings on the NHPA and Nationwide Permit 12 regarding sacred sites. And it was a little bit of a hasty process. We were seeking to stop construction at that time because of lack of proper consultation under the NHPA. And at that time, the Corps was getting close to the river and was getting close to what we considered to be sacred sites. And it was a hard-fought fight in the court, but ultimately we lost. And so on September, this says September 6th, but I think it's actually September 9th, the court issued its opinion stating that the consultation efforts on the part of the Corps were sufficient, despite all the problems I already talked about, and denied the injunction. But dramatically, just an hour after that decision issued, DOJ, DOI, and the Corps issued a joint statement saying that they were not going to grant the easement that had not been addressed yet, and therefore, they would go back and reconsider things, but the easement was being withheld. And that brings me to the water protector movement. Some of you may have heard that Energy Transfer Partners has recently sued Greenpeace and the Sierra Club related to the water protector movement and the delays that occurred. in this litigation. And their very cynical and false and frankly obscene argument is that money-hungry groups like Greenpeace and the Sierra Club and Earth Justice whipped up the Indians into a frenzy to go camp down at Cannonball and disrupt their pipeline operations, as though these tribal people would be just sitting at home, hanging out, had it not been for these greedy environmental groups coming in and making them be activists. But in reality, it was a grassroots movement started by Lakota women and youth. There was a summer camp down on the Cannonball as early as April 2016. And I was so proud to see in July 2016, a group of Lakota youth ran from North Dakota to DC to present their concerns about the pipeline. And so I have some pictures. Here's the camp in April, just a small group of people. Here's the Lakota runners. And so the way that the litigation affected the water protector movement was that Labor Day weekend, before that opinion had issued, the Standing Rock Sioux tribe identified some sacred sites very close to where DAPL was then doing construction, and were concerned that they were about to plow over some really important stuff. So they submitted a supplemental declaration saying, look, you know, our archaeologist was out there and there are these stone cairns and so on and so forth. So that was Friday, September 2nd, right before the holiday. And you know, they submitted maps and graphs and so on and so forth. September 3rd, Dakota Access bulldozed precisely the areas identified by Standing Rock, and we had those big clashes with the water protectors that resulted from that. We ended up moving for a TRO that was granted in part, but here to show you, this is what one of those maps looked like. And sadly, here's Dakota Access plowing right through exactly where we told them those were. And at that point, they had their private security with dogs. They were macing people, sicking their dogs on people. This dog bit numerous people, including a relative of mine. And I always like to brag on my relatives. That's my cousin, Tashina Sapowi Smith. And I'm proud of her. She's on line 3 right now fighting that fight. But from there, the movement grew and grew and into the winter. And so what that did, though, you know, we understand that the water protectors raised the profile of our issue. Something that was very important to us as tribal people suddenly became something that all of you people out in mainstream America also were concerned about, and I'm sure you saw a lot of Facebook campaigns and so on and so forth. But I believe that it also raised the profile within the Obama administration, and I think that that's a lot of the reason why we got what we think of as a timeout in September, when the administration said, hey, we're going to go back and take a second look. And so and that was a godsend for us because, you know, it gave us extra time to develop the record. And so we did just that. And we worked with the agencies. We had several meetings with Mr. Roberts and my chairman, who's an awesome but sometimes intimidating guy. And we, you know, went back and hired experts to look at spill risk, to look at hydrology, to look at wildlife biology. And so we took that time between September and December to put together new reports demonstrating just why this pipeline is such a huge risk for us. And I'm going to speak up to a little further in my presentation. But ultimately, as Mr. Roberts indicated, in December, the Obama administration and the Corps, looking at these materials that were prepared by me and by my colleagues, demonstrating why this pipeline was such a threat to our water, the Corps determined that in fact an EIS was required and that they would consider rerouting, and that we would finally get the environmental review that we had been seeking since early in 2015. Sadly, however, we were not looking forward then to a Clinton administration. In January, we're looking forward to a Trump administration. And so those gains were not very long-lived. And he eventually granted the easement on February 7th. So we continued a long bout of litigation starting early last year. As soon as the easement was granted, we filed a motion for TRO and preliminary injunction under RFRA. And getting back to some of the stuff that Mr. Smith said, our allegation was that the mere presence of oil under the river desecrates its ritual purity. Something like how Catholics feel about a consecrated host, or how kosher or halal food is treated by adherents of Judaism and Islam. And we were not successful, but we did do preliminary injunction, summary judgment motions later that spring, and we were successful. So in June, we received a decision where the court found that the Corps' decision was arbitrary and capricious on 3 issues. First was environmental justice, that the Corps failed to consider the risk of a spill in the environmental justice context. Second, that the Corps had failed to address the risk of a spill in terms of treaty rights, our treaty right to hunt and fish and take animals that would be affected by the waters of Lake Oahe. And then third, a very interesting ruling, that the Corps had failed to consider the extent to which the project was highly controversial. And that doesn't, under CEQA regulations, and that doesn't mean highly controversial because there were lots of people fighting and it was in the news, but rather that our experts had come and challenged the data and methods upon which the Corps relied in order to make its decision. And so, we, in the wake of this, have really changed the way that we look at consultation. I'm going to jump ahead. My mom always says never give an Indian a microphone because they just talk and talk and talk. And I really did just talk and talk and talk. So these are some of our lessons. We had such great success cooperating with our allies, with the green groups, with intertribal efforts, and down on the KXL, Bold, Nebraska, and those people, those guys are working together. I just was at a meeting a few weeks ago with the Great Plains Tribal Chairmen's Association and Bold, talking about strategies moving forward, legal strategies and strategies on the ground, and things of that nature. But we are engaging proactively in consultation. We've taken a lot of lessons from the consultation on consultation, and my tribe is currently consulting with the EPA on the Waters of the United States rule, and on a uranium mine that's going into the Black Hills. And we have found that the EPA is very solicitous of us. They have taken lessons themselves from the way that DAPL turned out and the difficulty that they had. And so we are very lucky to be living in this time when our people are working together, Indians and non-Indians. And we have a lot of challenges ahead of us, but it has been a process that I think has awakened people, and I think that it has motivated people, and so I'm very gratified by that. So, thank you.
In the interest of time and keeping on our schedule, we're going to leave it at that with our great presenters, but I encourage you to ask them questions individually if you have the chance. But please join me again in thanking the